my talk, I was going to talk about specifically ART legal issues, so donors, surrogates, embryos, and even if you're not in a position where you might be turning to sperm donation or egg donation or embryos or surrogates, embryos, if you're going through IVF, are still an issue because even if it's your own genetics, there are lots of crazy legal cases out there and things to be aware of when it comes to going through IVF and having embryos. I'll also talk about LGBT family protection. And any of these areas, like I can speed through or talk more about. So feel free to say that's what I'm curious about, and I'll try to vary it. And I will talk about estate planning briefly, just because it is important to any growing family and most families in general. So I have to give a disclaimer, because I'm an attorney. So no attorney-client relationship is formed by this presentation. I'm just doing it for educational purposes. So if you tell me you murdered someone in this room, I can't keep that secret necessarily. Also, people are listening. So we're not representing you, because there's some certain legal aspects that go with that, but I'm happy to if you want to come to me, and I can. I'm licensed to practice law in California, Colorado, and New Mexico. So any other jurisdiction where you might have legal problems, I would refer you to an attorney in that area. And of course, I would say attorneys are your friends. That is the message of this talk, is attorneys are your friends. We can help you avoid legal issues before they occur. So please don't, that is a message. We want to help you, and most of us, me included, do free consults, and we're always happy to help kind of understand the legal issues before you go into any kind of arrangement. And so with me, especially if you're doing egg donation, sperm donation, forming embryos, using a surrogate, I'm always happy to help. Like everyone else, I'd love to talk about myself, so I will do that briefly. So as I mentioned, I have a law firm. I co-own Colorado Surrogacy. I also write a weekly column on assisted reproductive technology legal issues for a website called AboveTheLaw.com. And every week there's a new legislation, new case, so it's kind of hard to, even with a weekly column, it's hard. I always have to pick and choose which one to write about. I also co-host a podcast called I Want to Put a Baby in You. So if any of you are podcast listeners, you can go on the iTunes or any kind of podcast app you have. That's our logo, the sperm with the headphones on. We like to be funny, but we interview surrogates, donors, people who go through embryo donation and adoption. We have professionals as well, so we've had doctors, mental health professionals, really the whole gamut. I feel like it's really, our mission is to get the stories and information out there. So especially if people are like, I don't know anyone who's been through this, it's a nice way to get to hear other people's stories. So we'll talk about ART intro, third-party reproduction, embryos, LGBT family planning, estate planning. So for legally, when I talk about assisted reproductive technology, it includes all of this. So sperm donation, egg donation, embryo donation, and just so you know, embryo donation versus adoption is a legal term of art. So generally what I do is embryo donation, because adoption is highly regulated. When you talk about adopting a child, it's a home study, it's background checks, and currently, legally in Colorado and most states, embryos are considered property or quasi-property, which we'll talk more about. And so you can transfer embryo rights via contract without having to go through a home study and that other part of kind of a live human adoption. So we generally talk embryo donation, but there are organizations that do embryo adoption. So Snowflakes is here, they're one of the presenters, and they treat embryo adoptions like a human adoption. So they, like a born child, adopt, not like an animal, like a born human adoption, where they have recipients do home studies and those elements. So it includes IVF, IUI, genetic surrogacy, also known as traditional surrogacy, gestational surrogacy, cryopreservation of gametes and embryos, and there's lots of crazy, so I also do whole talks about post-death gamete harvesting and post-death conception, which have their own kind of set of issues. And anytime you're freezing your gametes or your embryos are being made, it's worth thinking about what happens if someone dies. Is it okay that someone uses my genetic material? What are our plans? So worth at least putting some thought into. So as most people are aware, assisted reproductive technology has changed the natural limits to reproduction. We now know that a 70-year-old woman can give birth. That's happened multiple times now. Everyone knows Octomom, that one person can give birth to 8 children at once. We're now seeing 3-parent embryos made where genetic material from 3 different persons are used to form one embryo. And the science is saying that pretty soon we'll be able to make embryos from 2 persons that might be the same sex. So they can take cells, turn them into eggs or sperm. So we don't have that with humans yet, but they've done it with animals, and they're expecting it might be a possibility in the next few years. We, of course, also know that non-biologically related children can be carried to birth by an unrelated woman. That's gestational surrogacy, generally becoming very common. And children can be born years after the death of a biological parent. So you can combine that, and you can have a 70-year-old woman giving birth to 8 children at once to the bio parents being dead, and there can be crazy scenarios thanks to combinations of all of this. So first, to talk briefly about sperm donation. So sperm donation is very common. Sometimes people aren't able to use their own sperm. They could be a same-sex couple. They could be an individual. In Colorado, we have a statute that talks about sperm donation specifically, and that's 194106. One of the key elements of that statute is that it says you have to use a licensed physician or an advanced practice nurse to do the procedure. Meaning, if you are a single woman or you are a same-sex couple, if you get your friend's sperm or somehow obtain other sperm and you do it at home, it does not fall under the statute. So you have no protection, meaning if you're the recipient, you might not be the legal parent of the child, and the donor may be able to make legal claims to being a parent. And so the Craigslist case, so there's a very famous case for attorneys in this world that always refer to, because often people are like, my friend's gonna donate, it'll be fine, we fully trust him, he trusts us. So there was this case in Kansas which has an almost identical statute to Colorado, where same-sex couple had a known donor, they entered a contract, but they did it themselves. They did an at-home insemination, conceived a child, and the couple fell in hard times, so one became disabled and had assistance for that. And the state of Kansas, seeing that she was receiving public funds, went after the donor for child support, saying that he was not a donor, he was a legal parent to the child because they did not follow the statute, and they wanted to seek child support from him. And that case went on for like 5 years. And in that case, only because there was a second mother who had ultimately determined to have greater legal claims, she finally won legal rights to her child. If there hadn't been another mother, if they hadn't fought that through the appellate levels, and luckily attorneys like me, like there was multiple attorneys working on it for free just because we felt so passionate about how bad a result that was. But it is the legal reality that even if you're like, I trust the donor trusts us, the state can come after you, and we've seen it happen. So I don't know if it's happening in Colorado yet, but I wouldn't test it. So the other big issue with sperm donation, as well as with egg donation, is anonymity issues. And these are becoming bigger and bigger, especially with, well, we'll talk about the next slide, 23andMe, Ancestry.com. So the default was that everyone who used a sperm bank, it would always be anonymous, and that's just how it used to work. And now, given the ability to find each other, most sperm banks offer ID open or letting you know from the beginning. But there is this evolving right where some countries will say a donor has an absolute right to anonymity and will protect that. So Spain, for example, protects anonymity for donors. But other countries are evolving to say that no, our law should protect the children, and that children conceived from donation have a right to know their biological history. So even in Australia, we've seen where they had a law, so at first they protected anonymity, then they changed the law saying from this year forward, there is no protection, that you can be found by your biological children after 18. And then they changed the law again in 2017 saying, no, it doesn't matter when you donated, the children have a right to know their biological history, and abolish the anonymity. So even if you think, I'm going into this anonymously now, anyone can find you eventually. So that's my joke. Married, no kids. Well, I was a sperm donor. I may have dozens. Anyway, yeah, so 23andMe has become a big part of this, and there's been really fascinating cases. So because many banks still say we're protecting anonymity for donors, we've seen a case where, so there was a case in Seattle where a woman used a sperm donor from a bank, and then her child did 23andMe, and they found the mother of the donor. And on the site they said, hey, we're related, you know, I don't know if this is okay, but want to know we're here. The mother reached out to her son. The son contacted the sperm bank. The sperm bank sent a demand letter of $20,000 to the mother of the child saying you breached our contract that said you would not seek out the donor. This has been a breach of it, and we are not only are we suing you for $20,000, but we are taking back the 4 vials of sperm you had on stock, where she had planned on having a biological sibling to her child. So, I mean, I think it's an incredibly aggressive stance the sperm bank would take, but I think it's important if you are looking at sperm banks, to know what you're signing, to read it or have an attorney take a quick look. Because is there something like that? Are they going to sue me if I do 23andMe? And what if one of the relatives of the sperm, of my sperm donor reaches out to me? How would that look? So it's important to know kind of the legal pitfalls in this area. The other scary part with 23andMe and Ancestry.com is that a lot of people are finding out, especially if they were conceived 20, 30 years ago, that the fertility doctor is actually their biological parent. So more and more cases are coming out like that, which are pretty worrisome. And also mixed up in other misused gametes where they said, we are using the father and it's not, of the couple, and it's not who was used. So hopefully that'll become less common now that they know the information is easily accessible, but it's a reality. So egg donation, also very common. It's still a default that it be anonymous with more and more couples. So I do a ton of egg donation agreements, and I would say probably 90% are still anonymous, where the donor intends to be anonymous and the recipients intend not to find her. But I think, especially as things evolve, more people are asking, let's have an agreement from the beginning of expectations of knowledge later. The other big issue, legally, the other issues when it comes to egg donation, which also applies to sperm donation embryos, is what if someone donates gametes to you or you receive them, what is done with leftovers? So if I donate my eggs and I have a really good retrieval and I have 30 eggs and 25 of them become embryos and this family has 2 children, are they donating to 23 other families, and do I have 23 other genetic children out there? So we see a lot of egg donors who are putting kind of restrictions saying, don't donate to others without my permission, or don't donate at all. And interestingly, we sometimes see the other way, where people feel very strongly about, I'm donating for life and I want to help people and I want those embryos to be used, so I require you to donate to others. So it's always interesting to see that there is a spectrum and to go into it knowing what's important to you and what you want. And if you're the recipient, something to always think about is genetically linked children to yours. So if you use a donor, sperm donor, egg donor, does my child have 100 half-siblings out there that they should be aware of? Medical liability can always be an issue to worry about if you're in an egg donation agreement. What happens if there's complications? Who's responsible for that? And then, of course, future contact. And the DSR, so the Donor Sibling Registry, is this popular registry for donor-conceived children. And it's also become a way that recipients of gametes can contact their donor without knowing who they are. So they can say, donor 1632, my child has a burning question, like, were you a savant at the saxophone, because they're suddenly talented, or whatever question it might be, they can reach out without saying who they are and letting all their identity be known. It can also be a way to find siblings. Surrogacy. So as you know, I have a surrogacy matching and support organization. It is one of my legal specialties. So the law of surrogacy varies state by state. Some states it's still illegal. So Michigan, it's criminalized. New York, it's illegal to have a paid or compensated surrogacy. You can only have altruistic surrogacy. But even in those states, they have proposed laws in the last couple of years to support surrogacy. In the other states, DC, Washington, New Jersey, all had made it illegal to do paid surrogacy. And in the last couple of years, they changed their law. So we've definitely seen a pro-surrogacy movement in the United States. But that's not the same in the rest of the world. And there's still states that are dangerous. The law that applies is generally where your child is born. So if you're thinking about using a surrogate, it's really important to know where she lives and where the child will be born. In Colorado, we have no surrogacy statute. So it's not illegal because there's nothing that prevents it, but there's also nothing that says how it's done. So in states like California, there's a statute that says this has to be done, you have to have independent counsel, you have to do this, you have to disclose medical, blah, blah, blah. We don't have anything in Colorado. But what we do have is we have a court system that's been friendly to surrogacy. So pre-birth orders, so having a legal court order say who the legal parents are before the child is born is done very simply in Colorado. And we apply everything to Boulder County, this very liberal jurisdiction, that's happy to take, they're happy to hear it as long as she lives anywhere in Colorado. Less applicable, except for our friends abroad, is surrogacy abroad. So there has definitely been a movement in the opposite direction internationally with surrogacy, where most of Europe is anti-surrogacy. Either they prohibit compensated surrogacy or all surrogacy. An exception is the Ukraine. But many countries have seen kind of bad cases, and we always say bad cases make bad law. So there's been, like, one of the horror stories that happened was this case called the Baby Gamete case. This couple from Australia went to Thailand to use a surrogate. Twins were conceived. One of the babies was determined to have Down syndrome, and they ended up leaving the country with the baby, the twin, that did not have Down syndrome. So as you can imagine, that was horrific that they would leave behind one of their children. Digging into it, the case is the facts are a little bit more complicated, where they were told by the agency that they couldn't take their baby, and it's really like there's different sides of it, but still just horrific to see or think that would happen. So most of Asia, which used to be a big hotspot for surrogacy, so India, Thailand, Cambodia, have mostly shut down surrogacy for international couples. Nepal as well. I mean, each of these are like cases. So there was an earthquake in Nepal a few years ago, and these like stories of these couples coming and airlifting their babies out of like this like disastrous, these towns that were just like demolished by the earthquakes, and of course leaving behind the woman who carried it, who carried the child. So has really put a bad taste for surrogacy for a lot of countries. I mean, I think in the United States we take a very different approach, where we're very careful about who we recruit, that there's no coercion, that they're doing it willingly, that the reason why they're a surrogate is because they want to help someone else, and that they're not being controlled or told what to do with their body, and that we're very, very careful about balancing those rights when it comes to surrogacy. And I think because of that approach of everyone being very careful, surrogacy has really flourished here. But despite the fact that it's flourished, there are certain attorneys, certain groups that are very anti-surrogacy, even in the United States. So we've had some horror cases here that have been attempted to take to the Supreme Court. So SCOTUS is the Supreme Court of the United States. So two kind of horror surrogacy cases. The Melissa Cook case was a little bit famous, where this woman in California agreed to be a surrogate to a single man in Georgia. They transferred 3 embryos, all 3 took. She was carrying triplets. He asked her to reduce the pregnancy, meaning to terminate 1 or 2 of the fetuses. His claim was for medical reasons, to make sure they don't all die, which is a risk if you're carrying multiples. It's possible that all fetuses could be endangered if you don't reduce. She refused. She gave birth to all 3 children. She brought a case in California saying she should be the legal parent of baby C for sure, and also baby A and B. She lost, and then they took it all the way to the Supreme Court, saying that surrogacy is not constitutional. And to be fair, like, that is a horror case, right? That she was asked to reduce, and you can understand how she might want to protect those children. But the law in California, as well as many states, is clear that a surrogate cannot change her mind and seek rights to the child. One more horror case, the superfetation case. So another horror. So surrogacy is like really good when it's really well done, but just to beware of the horror stories. So there was this other horror case in California that's ongoing, where this woman, Jessica Allen, she agreed to be a surrogate to a Chinese couple. So they transferred 1 embryo to her. They found out she was pregnant with twins. Everyone assumed that the embryo had split. When she gave birth, the Chinese intended mother was like, hey, my twins don't look alike, like, what's going on? They did genetic testing. Sure enough, there's something called superfetation, where you can get pregnant while you're carrying a child already. So she got pregnant with her own child while carrying their child. Unfortunately, in that case, the agency kept her own child. So the Chinese couple took their genetic child, went home to China. They left the other child, and the agency refused to give Jessica her child back. And now she is suing them, which is pretty fair. And they were arguing, we're going to put your child up for adoption because you haven't paid us back the money you owed. So it's also really important to work with a good agency that's ethical and on your side too. Embryos. So even if you're not doing embryo donation, if you're just going through IVF, it's important to have a little bit of a concept about what embryos are legally. And the answer is we don't know. So some states consider embryos property, some consider them persons, and others consider this middle ground of quasi-property or property with special characteristics. So Georgia, the state of Georgia specifically has a statute that says you have to adopt embryos. It treats embryos like persons. The state of Louisiana says that embryos are juridical persons and they can sue or be sued. And we've actually seen a case where embryos tried to sue someone, specifically Sofia Vergara, who is famous from Modern Family. She had embryos formed with an fiance at the time. They broke up. He wants to use them, she doesn't. And he had the embryos, who he named, sue her in Louisiana. And in that case, we saw it dismissed because they didn't have jurisdiction in Louisiana, because the embryos were in Los Angeles and California. He wasn't there, they didn't have enough. But we don't know if the embryos actually had been there, if they could have won to say we are persons and have a right to be brought to life. Colorado did have its own embryo disposition case though, so we had a case go all the way to Supreme Court where a divorcing couple had gone through IVF together, had embryos formed, successfully had 3 children. Once they divorced, Mrs. Rook said, you promised me a large family, I want to use the embryos. Mr. Rook says, no, I don't want any more children with you, you cannot use them. The trial court said he won. The appellate court ruled in his favor too. It all went to the Supreme Court, where she argued that, so almost universally, the person wishing not to procreate with embryos tends to win, saying you have a right not to procreate. But there are a couple exceptions, and those cases are when a woman had cancer and she had no other way to have a biological child. We've had 2 cases where they won, now 3 because another one came out. And in those cases, the courts let a woman use the embryos over the objection of the male genetic provider. In this case, it went to the Supreme Court, and they determined in Colorado that the appellate court had not assessed the case correctly, that they had looked at her ability to afford children, saying, no, you don't make enough money to have another child, the fact that she already had 3 children, and the fact that she could just adopt. And the Supreme Court said those are not appropriate factors to consider, that you can't look at the fact that you can adopt because that's not the same thing as having a biological child, and you can't really look at the fact of whether someone can afford a child to determine whether they have rights to embryos. So that's been sent back to the trial court to determine whether she does have a right in these children. But the very important part, that they did say that you look to the agreement of the parties first before you weigh their interests. So if you are forming embryos together, make sure that your agreement is very clear. What happens if we divorce? What happens if one of us dies? And make sure that you're on the same page of understanding what that looks like. But even if you're not, the scary part is there's a law in Arizona that says if a couple is divorcing in Arizona, the judge must award the embryos to the divorcing spouse most likely to make them develop to birth. So even if you had an agreement in place, even if you had something signed with the clinic that says, upon divorce they're destroyed, the reality is someone could move to Arizona, file for divorce, and have rights to use embryos. So know that. Most attorneys think that this is probably unconstitutional eventually when it's challenged, but right now is the law in the books. The clinic will go over this if you're making embryos, but the general options are storing indefinitely, destruction, donation to science research, or donation to others, and they all have kind of their own legal issues. Postmortem, retrieval, and posthumous conception. Again, this is something I could talk about for hours. There's really, really fascinating cases, but I would say the most common thing that happens for me as an attorney is someone calls me and says, hey, my fiance or my spouse just died, and we had planned on having children together. Can I retrieve their sperm or their eggs? And the answer is, we don't know. There is no law on it. However, if you put, the biggest issue is consent. So if you think that's a possibility, honestly, even if you just put it in your handwriting, dear sweetie, you can use my eggs if I die for creating children, that is probably likely to get you where you want to be. But without consent, it's really unclear. And it's really bizarre how the cases kind of fall, where we had 3 in the last few years in Colorado where someone suddenly died. And the 2 of them where the person was rushed to the hospital and died in the hospital said, no, we won't do it. The one where the person died on impact and went to the coroner's office, the coroner said yes and allowed it to happen, which is kind of this bizarre that because they died faster, that this person allowed the sperm to be retrieved, and now the grieving spouse can have a child. So there was a couple in Texas where they had embryos. They went through IVF, had embryos when they were murdered. They had already had a son, so they had a 2-year-old son when they died, and the probate judge had to determine what to do with the embryos, and the judge ruled that the 2-year-old child would receive the embryos and could decide at age 18 whether to bring them to life or not, which is kind of there. Really quickly, LGBT issues, birth certificates. So post Obergefell, if you were in a same-sex marriage, there is a marital presumption. So if you are married to someone and give birth, it is assumed that because you gave birth, you're the parent of the child, and because you're married, the spouse is the second parent of the child. unfortunately, with LGBT parents, that the good news is if you're married to a woman, you give birth, she will naturally go on the birth certificate, but states don't have to recognize a birth certificate. So even if I am named on a birth certificate, another state can say, that is an administrative document of that state, and I only have to follow a court order. So this can be really scary. We've never seen it questioned in a heterosexual couple. It tends to be an issue of discrimination, but it is a reality that if you are married to a woman and she goes on the birth certificate, that might not be enough. Even though you have a legal presumption of parenthood, it might not be enough to protect her in another jurisdiction. And we have seen a lot of discrimination in the area, so if that is a concern, it's something I can talk to you or friends about. Specifically, there was a case that went all the way to the Mississippi Supreme Court where a same-sex couple was divorcing, and they ruled that the anonymous sperm donor was the second legal parent to the child, not the woman that had raised the child who had been married to the biological mother. So, and other cases we've seen with discrimination. It's really big right now where we're seeing all these cases where couples went abroad to use a surrogate or have a child there, and when they come back to the United States, we're seeing them denied U.S. citizenship. And it's complicated and ugly, but there's been a lot of cases like this. So like 3 in the last few months have become really public. So the answer is generally adoption or pre-birth order, or being really careful if you go abroad. Okay, in my last 4 minutes, estate planning, also really big. No matter who you are, you should probably have an estate plan. There are protections while you're still alive and protections when you pass. So the big protections while you're still living, having a living will that says what your wishes are if you are incapacitated, having a medical power of attorney, which the flip side is having a person be able to make medical decisions for you. One of the really fascinating things about Colorado is there isn't a default person who is your medical power of attorney. So in other states, they'll say your spouse by default is, and they can make those decisions, or your parent is, and kind of have a hierarchy. We don't have that. So we've seen some really ugly cases where there'll be someone on life support and everyone in the like 99% of the family is saying like, we would not want her to suffer, please take her off. And like one third cousin who was like super religious being like, no, it's not God's plan. And then they can't do it because it's not clear, because there was no medical power of attorney. So it's worth having someone clearly named as who can make those decisions. After you pass, of course, the will is the basic one, instructions as to your last remains. If you're going through IVF or having any kind of gametes frozen, it's worth thinking about what happens to my sperm, my eggs, my embryos, what are my wishes in this area. So many horror stories about, like hours of horror stories of people who did not have a will. Jimi Hendrix, apparently they fought over his estate for 30 years. The guy who wrote The Girl with the Dragon Tattoo, he had a partner of 32 years, did not have a will, and so when he died, all of his like enormous fortune went to his estranged father and brother. So things to think about. Should I get my will online? So they say it's like pulling your own tooth with a pair of pliers instead of going to the dentist. Comparison. The problem is most online forms are not tailored for your needs, your family structure, your asset holding, your tax situation. The other part is correct execution. So under Colorado law, if you don't have 2 witnesses to your will, it is not an effective will. They won't look at it, the court won't consider it. One thing happens a lot is if I write a will, people think like, oh, I can just cross out and like change this name. That is ineffective. Like you have to, if you change a will, you have to do a codicil or do a new will. Same thing with execution of two witnesses, or else again, like the judge will completely ignore it if you're like, I write out my now hated brother. Like your brother gets it all. Lawyers are your friends. Oh, okay, look, I totally did on time. Any questions? So I would want to see what the bank said, but probably not. If you didn't do something,
it wasn't you, but
yeah.
it was the child.
If the clause is like, you will not seek them out, you're probably safe. But one thing that's important to know is that people think like, oh, I didn't do the test so they can't find me. But they've shown, like I went to a conference where they're showing like, if you don't do it, but your third cousin does it, like it is enough, like mathematically, they're like, boop, like you show up. Like, so a lot of people think like, I'm not gonna do the test so no one can find me, but
It could just be like an accident.
someone in your family does it and it's like enough to figure it out. So, and there's like whole professions now who like they help look at the test, look at ancestors, look at trees, and they can find people like that genetically. It's amazing. feel free to talk to me afterwards. Again, I love to talk to people about any legal issues they have. I'm always happy to help. So good luck to everyone. Thanks. Thank you. Excellent. Good.